morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll be providing another installation to our Anti-Federalist Papers series, going on number 30. So if you haven't gone back and watched 1 through 29, I would highly encourage you to do so, because understanding the Anti-Federalist Papers and the Federalist Papers will provide you a very well-rounded, advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will absolutely be necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. Like I said, we're going on to number 30. There are many places from which you can get a digital copy and paper copy of the Anti-Federalist Papers. Go ahead and get both. And if you haven't already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 30, they title it 30 through 31 just because the historical record makes it difficult, or the way the Anti-Federalists labeled their papers and titled their papers made it kind of difficult to specifically segment where each individual paper started and ended. Nevertheless, the information is just as veracious and valuable, rather invaluable. So number 30, you can say 30 through 31. I'm just going to go for 30. A Virginia Anti-Federalist on the issue of taxation. Published in the Freeman's Journal or the North American Intelligencer on October 31st, 1787, he says this: "It has been the language since the peace of the most virtuous and discerning men in America that the powers vested in Congress were inadequate to the procuring of the benefits that should result from the Union. It was found that our national character was sinking in the opinion of foreign nations, and that the selfish views of some of the states were likely to become the source of dangerous jealousy. The requisitions of Congress were set at naught. The government that represented the Union had not a shilling in its treasury to enable it to pay off the federal debts, nor had it any method within its power to alter its situation. It could make treaties of commerce, but could not enforce the observance of them, and it was felt that we were suffering from the restrictions of foreign nations, who, seeing the want of energy in our federal constitution and the unlikelihood of cooperation in 13 separate legislatures, had shackled our commerce without any dread of recrimination on our part. To obviate these grievances, it was that's weird, that's worded very weirdly. It was, I believe, the general opinion that new powers should be vested in Congress to enable it, in the amplest manner, to regulate the commerce, to lay and collect duties on the imports of the United States. Delegates were appointed by most of them for those purposes to a convention to be held at Annapolis in the September before last. A few of them met, and without waiting for the others who were coming on, they dissolved the convention after resolving among themselves that the powers vested in them were not sufficiently extensive, and that they would apply to the legislatures of the several states which they represented to appoint members to another convention with powers to new model the federal constitution. This, indeed, it has now done in the most unequivocal manner, nor has it stopped here, for it has fairly annihilated the constitution of each individual state." Doesn't that sound familiar? "It has proposed to you a high prerogative government, which, like Aaron's serpent, is to swallow up the rest. This is what the thinking people in America were apprehensive of. They knew how difficult it is to hit the golden mean, how natural the transition is from one extreme to another, from anarchy to tyranny, from the inconvenient laxity of 13 separate governments to the too sharp and grinding one, but which our sovereignty as a state was to vanish. In Article 1, Section 8 of the proposed Constitution, it is said, quote, 'Congress shall have power to lay and collect taxes, duties, imposts, and excises.' Oh, but the Federalists said, y'all have no need to worry. Obviously, Congress will only stick to these taxes, and we provided very clear definitions of duties, imposts, and excises. There will never be an individual income tax.' Do y'all remember that Federalist paper? There will never be. They won't go outside the boundaries. And hey, let's say if they do, the state legislatures will keep them in line. Do you remember that Federalist paper? Do you think that came true? Are these concerns warranted? I'll let you answer that question for yourself. Imposts and excises. Are you then, Virginians, about to abandon your country to the depredations of excisemen and the pressure of excise laws? Did it ever enter the mind of any one of you that you could live to see the day that any other government but the General Assembly of Virginia should have power of direct taxation in this state? Predicting, to a T, the individual income tax. How few of you ever expected to see excise laws, those instruments of tyranny, enforced in your country? But who could imagine that any man but a Virginian, were they found to be necessary, would ever have a voice towards enacting them? That any tribunal but the courts of Virginia would be allowed to take cognizance of disputes between her citizens and their tax gatherers and excisemen? And that, if ever it should be found necessary to curse this land with these hateful excisemen, anyone but a fellow citizen should be entrusted with that office. For my part, I cannot discover the necessity there was of allowing Congress to subject us to excise laws unless that, considering the extensiveness of the single republic into which this Constitution would collect all the others, and the well-known difficulty of governing large republics with harmony and ease, it was thought expedient to bit our mouths with massive curbs, to break us, bridled with excise laws and managed by excise men into an uniform, sober pace, and thus gradually tame the troublesome metal of freemen. What a pretty way to say that. This necessity could not, surely, arise from the desire of furnishing Congress with a sufficient revenue to enable it to exercise the prerogatives which every friend to America would wish to see vested in it. As it would, by unanimous consent, have the management of the impost, it could increase it to any amount, and this would fall sufficiently uniform on everyone according to his ability. Or, were this not found sufficient, could not the deficiency be made up by requisitions to the states? So he's saying, we don't need this new government to raise revenues. The articles already provide a very sufficient, very able, and representative mode by which revenue can be raised. Could it not have been made an article of the federal Constitution that if any of them refuse their quota, Congress may be allowed to make it up by an increase of the impost on that particular state so refusing? This would surely be a sufficient security to Congress that their requisitions would be punctually complied with. In any dispute between you and the revenue officers and excisemen of Congress, it is true that it is provided the trial shall be in the first instance within the state, though before a federal tribunal. It is said in paragraph 3, section 2, article 3, quote, the trial of all crimes except in cases of impeachments shall be by jury, and such trial shall be held in the state where the crime shall be committed. But what does this avail when an appeal will lie against you to the Supreme Federal Court? In the paragraph preceding the one just now quoted, it is said, quote, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. But where is this Supreme Court to sit? Will it not be where Congress shall fix its residence? Thither, then, you will be carried for trial. Who are to be your jury? Is there any provision made that you shall have a veneer from your country, a veneer from your county, or even from your state, as they please to call it? Not you are to be tried within the territory of Congress, and Congress itself is to be a party. You are to be deprived of the benefit of a jury from your vicinage, that boast and birthright of a free man. Should it not at least have been provided that those revenue officers and excisemen against whom free governments have always justly entertained a jealousy should be citizens of the state? Was it inadmissible that they should be endued with the bowels of fellow citizens? Are we not to expect that New England will now send us revenue officers instead of onions and apples? When you observe that the few places already under Congress in this state are in the hands of strangers, you will own that my suspicion is not without some foundation. And if the first cause of it be required, those who have served in Congress can tell you that the New England delegates to that assembly have always stood by each other and have formed a firm phalanx, which the Southern delegates have not. That, on the contrary, the maneuvers of the former have been commonly engaged with success in dividing the latter against each other. Signed, Cato Uticensis. Cato Uticensis. Excellent. So that is all that gentleman had to say in Anti-Federalist number 30. If you have any questions about what was said in number 30, maybe questions about what was said in the preceding papers, or there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in a great state, in the great state, not in a great state, in the great state of Texas, with the Calhoun School of Law, to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day. I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.